The ultimate goal of any one of our clients who's charged with impaired driving or a DUI is to ultimately get the charge dropped or withdrawn. I mean, that's why you hire a lawyer, isn't it? And this is the vexing question, which I explained to them. How can we go about doing that? Are there ways and means of doing it? Every case is different, there's no question, but we're often able to get charges dropped and withdrawn, or we're often able to plead to a careless driving and have the charge withdrawn. Now, how do we do that? Well, I'll explain the steps involved. Now, first of all, the first thing we do when you hire us is we get a hold of the disclosure. That's all of the police notes, reports, alcohol influence reports, breath certificates, surveillance video at the police station, you name it, we get it, consisting of, the average DUI case now, there's like 60, 70, 80, 100 pages, sometimes more of notes, believe it or not, with videos, etc., of you in the breath room, of surveillance in the cells. We need all of this stuff to formulate a proper opinion. So when I get that, I spend several hours reviewing all of the videos and the paper disclosure, and I formulate an opinion about the strengths and weaknesses of the Crown case. To simplify it, DUI and impaired driving law is very complicated. And often the police make procedural errors. They don't process the file properly. There's a real checklist of procedures, and it's difficult. I feel sorry for police at times because there's so many things they've got to do properly. There's constitutional rights that you have and charter applications, and I can spot mistakes effectively that the police have made. I can determine if the impaired's weak because, it's equally consistent with a motor vehicle accident, the symptoms, or the symptoms don't go far enough. It's a very technical area, there's no question. And there's thousands of cases on point. We understand this. We're constantly reading case law and constantly analyzing. So the bottom line, after about 3 or 4 hours of legal work, I'm able to fully understand the strengths and weaknesses of that case and ready to provide you with an opinion. I also need your version of events, though. So I meet with you, I review all the case with you and tell you what I think about it, and I also receive your version of events, because that's very important, because your version in the context of the police version, I'm trying to conceptualize how to win. So I'll be able to provide you with an opinion about whether there are procedural errors, whether there are charter errors, the strength of them. Some errors are so obvious, it's a easily winning case. I hate to say a slam dunk, but I hesitate to ever say that to a client, but sometimes cases approach, if they're not a slam dunk, they approach it. Other cases, there's a good chance of winning, I can give you these odds within a range. Or it's 50-50, it depends on the judge, depends, interpretation of the case law, or it's a weaker case. We might win, but it's tough. Or look, this is a slam dunk Crown case. You crawled out of the vehicle drunk back to the police cruiser and were passed out drunk. I mean, a genius. No lawyer in the world can. We could revive Clarence Darrow from the States from the 20s, and he wouldn't be able to win that case. So some cases are unwinnable. So the bottom line is I now have an idea about whether there's errors, police errors, charter errors, and if there are, that is great, because it forms my basis where I can meet with the Crown and attempt to convince the Crown to drop the charge. Now, if it's a charter issue, and by the way, I also get your complete background, because the Crown wants to know you're a good person, you coach baseball, you're a teacher, got no prior criminal record, community service, that all goes to your credit. Although it's not sway the day, it helps, okay? So when I meet with the Crown, in order to get one of these charges dropped in Ontario, the one way to do it, if there's a convincing charter argument that your rights are breached, your rights to counsel was breached, you were filmed nude in the cells without being given a privacy gun, there was no reasonable probable grounds, and you refused. I mean, there's literally hundreds of defenses and technicalities. I will find it, and if it's something that can't be fixed, and that's the operative thing, if it's something that can't be fixed, in other words, the Crown can go back to the police and have the police amend their notes, I will disclose it to the Crown, and attempt to get it withdrawn. And you know, I don't go lightly to the Crown. If I think there's a mistake, hopefully I've got enough credibility amongst the Crowns now. When I bring up something, they know I'm not fooling around. I just don't make these things up, and I'm often successful, and as our other lawyers are, in getting them to drop the charges because there's no reasonable prospect of conviction. Some cases there's simply no reasonable prospect of conviction. Now, in other cases, by the way, it's more 50-50. It depends on the Crown you go to. When it's a 50-50 charter case like that, some Crowns are more liberal than others in giving deals or withdrawing charges. You've got to know your Crown. You try and pick your Crown if you can, if counties let you do that. Some do, some don't, that you meet with. Some are assigned, by the way, and others you kind of pick up the phone, or at least I do, and or email them and deal with certain Crowns. But I'm finding these days, particularly during COVID, if you've got something to hang your hat on, if there's a procedure error that's 50-50 chance to win, I'm finding most Crowns in the province are playing ball. And if they're not outright withdrawing, they're offering careless driving plea under the Highway Traffic Act and withdrawing the criminal charge. That's an absolute win. I mean, God, if you get a careless driving plea where you might lose your license for only 3 months, get the criminal charges withdrawn, that is always a win. I mean, a careless driving plea, even halfway through the trial when you're offered, I consider it a win. There's no question about that. So no reasonable prospect of conviction, great, withdraw the charge. Hey, 50-50 case, Liberal Crown, offer a careless. And by the way, Crowns are offering carelesses during COVID much more. Again, we're getting great results whenever we can hang our hat on a mistake. It's great. And they're offering, a lot of Crown attorneys, there's a new policy that they'll consider careless on low breath readings, which is great too, as long as there's no aggravating circumstances like children in the car or a motor vehicle accident. We can often get carelesses offered for low readings. Carelesses are always a win. Now, there's some times where the Crown, on a 50-50 case, they're not offering any deals. I say to my client, let's just go to trial. We got a shot at winning. The client wants to roll the dice. It's not a bad case, or maybe it's better than 50-50. We have to file a charter application at least 30 days before the trial, sometimes much earlier than that because there's a confirmation hearing that they want it filed, say, 3 months before. Sometimes the Crown never comes to grips with their file when they meet with me because they haven't reviewed it very well. I can't convince them. But a lot of times they'll offer that careless, even on the day of trial. Oh my God, they look at my charter application, they read the case law. He's right. No, I know I'm right because I told you that 10 months ago, but now you're coming to grips with it. It's a little bit like you're writing exams for some Crowns. They don't study till the night before and then they go, oh my God, I got a problem here. And the next day we get a careless. There's nothing I can do about it. There's nothing I could do to convince him for until he saw all the materials. We had to do all that legal work and you had to spend all those legal fees. I mean, my God, that has happened to me and our firm, our lawyers, hundreds of times throughout our career. Unfortunately, it's just the way of the world. But I like to get things dropped soon, get it careless soon, but some Crowns just won't play ball that way. But I'll tell you, there's great deals to be had during COVID. I hope the Liberal measures continue post-COVID because it's moving the court system nicely. And don't think because you're charged with impaired driving or DUI that you can't get this dropped. You may be able to if there's some issues in your case or if you have low readings. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.